Here we're going to be talking about Model Rule 1.13, Part A, Organization as a Client. Sometimes a lawyer represents an entity rather than an individual. This could be a business or a huge corporate conglomerate or a nonprofit like a private university or a large hospital system, a national fraternity or sorority system, or maybe a large religious organization or church. Keep in mind that some nonprofit organizations are actually very large and have a lot of money or assets, like Harvard University or the International Red Cross or even the Federalist Society. Now, the lawyer's role could be as in-house counsel in these situations, in which the lawyer is basically a full-time employee of the entity and has no other clients. Or they might be outside counsel, where the lawyer has, let's say, a law firm that represents a variety of clients, including some corporate entities. Large corporations usually have in-house counsel for their day-to-day work, especially for regulatory compliance work and contract review, and then they hire outside counsel for special matters like a major lawsuit or mergers and acquisitions. Now, there are some special rules about the lawyer's duties and responsibilities when representing an organization as the client, and these are embodied in Model Rule 1.13. Rule 1.13 applies to both in-house counsel and outside counsel for a corporate entity, regardless of whether it's for-profit or nonprofit. So with having that introduction, let's dive in. Rule 1.13a says, a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. This is a very important point, so make sure that you are very clear on this as a law student. The client is the entity itself, not the individual managers or officers or directors or owners or the employees. And sometimes these individuals don't understand this. They think that the lawyer represents their interests just because the lawyer represents the organization with which they are involved or where they work. In fact, sometimes they maybe even are the person who hired this lawyer. And so they think the lawyer is there to do their personal bidding. Comment 1 gives us a definition. An organization is a legal entity that acts only through officers, directors, employees, and shareholders. These are what we call the constituents of the corporate organizational client. So when we talk about some of the duties under the other model rules like confidentiality, it applies to the entity. But in practice, that means it's going to apply to communications from those constituents who can act on behalf of the entity, who have legal authority to do that. So it would not apply to all other communications a lawyer may have with other constituents, like lower level employees in the organization. They give an example about this in comment 2 to Rule 1.13. Let's say an organizational client asks its lawyer to investigate allegations of wrongdoing, to kind of do an internal audit. So if the lawyer conducts interviews and during that investigation with various employees or other constituents, those are going to be covered by the duty of confidentiality because the lawyer is acting at the behest of the corporate directors. It does not mean, however, that all the individual constituents of an organizational client are thereby the clients of the lawyer individually. This can have serious consequences. Comment 2 continues with a warning about lawyers sharing confidential corporate information with the entity's lower-level employees or other constituents. It says that a lawyer may not disclose to such constituents information relating to the representation except for disclosures authorized by the organizational client as part of carrying out the representation, or as otherwise allowed by Model Rule 1.6. So let's say that you are in-house counsel for a corporation and there's a big lawsuit or litigation underway. And people stop you in the hallway and ask you, hey, what's happening with our company's lawsuit or that litigation that we keep hearing about? Well, unless they're the people who are authorized to act on behalf of the corporation, you can't really talk to them about it. You have to say, I don't represent you. I know you work here. I represent the entity. This is one of the difficulties in practice of representing a corporate client or an entity, is you're frequently having these conversations of reminding people who you represent or helping people understand why you can't have a conversation with them about the legal matters of the organization. Some clients, corporate clients, have really bad ideas. And with organizational clients, you are probably not going to be in a position to make all of the business decisions for it. So the comments to this rule say, when constituents of the organization make decisions for it, ordinarily a lawyer must accept them, even if their utility or prudence is doubtful. So that means that decisions about business and operations, including ones entailing serious market risk, are not normally in the lawyer's province. They may ask your opinion, but they may not. This concludes our discussion of Model Rule 1.13, Section A. In the next video, we'll continue with Rule 1.13 by looking at the next few sections of this important rule.